Hello everyone, Assalamu alaikum. In our previous video, we have discussed about recovery of possession, and in this video, we will discuss about rescission of contract. So first, we need to know what is rescission of contract. Okay, I have taken a definition here. Here under contract law, rescission means unmaking of contract between the party. Rescission is the unwinding of the transaction. This is done to bring the party as far as possible back to the position in which they were before they entered into the contract. So by rescission of contract, the parties are tried to send back in a position where they were before the contract was made. So this is what the term rescission means. Now we will see what is written in specific relief act about the rescission of contract. First we will see section 35. Here it is written that any person interested in a contract in writing may sue to have it rescinded, and such rescission may be adjudged by the court in any of the following cases. So in which cases rescission will be adjudged is written in the following. So first here any person interested in contract. So rescission of contract can be claimed by any person interested in a contract, and when rescission will be adjudged is also written in section 35, which are following. First here written that where the contract is voidable or terminable by the plaintiff. So first, where the contract is voidable by the plaintiff, then plaintiff can ask for rescission of contract. So there are lots of situations under which a contract may be voidable by the plaintiff. There are a lot of situations, or there are a lot of sections under which a contract may be voidable. So first we will take a look under which a contract will be considered as a voidable contract, such as section 19, section 19A, 39, 53 and section 55 of the Contract Act. So these are the section under which a contract can be made voidable. So if a contract can be made voidable under this section, then the plaintiff and these power must be exercised by the plaintiff who wants to file a suit under the specific relief act for the rescission of contract. Then the court may rescind the contract. Here another thing I will say here, that rescission of contract is discretionary power for the court. So under some situation court may rescind, or in some situation court may not rescind. It is discretionary power of the court. Here it is written that may be adjourned. May be mean court has discretionary power when may be is written here. So here A sells a field to B. There is a right of way over the field of which A has direct personal knowledge, but which he conceals from B. B is entitled to have the contract resigned. So here A has the personal knowledge, and A is selling here the property or field, and A has the personal knowledge that right of way over the field was there, and B does not know about it, and A conceal from B. So here the situation makes the contract voidable at the option of B. So here B can apply for the rescission of contract. Here I want to visualize the illustration in the screen, like A and B here make the contract, and A concealed that here there is a way to go, but B does not know about this way, but and buys this property. Ultimately he knows that there is a way, so B has the option to make the contract voidable, and B can rescind the contract because it is voidable at the option of B. Now we will see another situation when court may adjust the contract as resigned, like where the contract is unlawful for cause not apparent on its face, and defendant is more to blame than the plaintiff. If the contract is unlawful and it is not apparent on its face, so first contract needs to be unlawful, then it is not apparent on its face, then also it needs to be showed that defendant is more to blame than the plaintiff. These three things need to be showed. Then under B, a court may adjust the contract as for rescission of contract. So here the illustration, if we take an illustration, an advocate induces his client B, a Hindu widow, to transfer property to him for the purpose of defrauding B's creditor. What A does, A transfer B's property, who is a Hindu widow, and what is the purpose of doing this? The purpose of doing this is to defraud B's creditor. So it is a unlawful, because for defrauding the creditor, if a property is transferred, then it is regarded as unlawful in the eye of law. So it is an unlawful. Now, so first element is the contract is unlawful. It is showed, and it is also not apparent on its face. And here defendant is more to blame than the plaintiff. So here who is more blame? Defendant. Defendant here is advocate, because advocate knows all the things about the unlawfulness of the contract, and he himself transfer the property to him. And here B, who comes to A for help, but he what A did? A transfer the property to himself, which is an unlawful under the law, and here A is more blame than the B, and A is here defendant. So B can ask for rescission of contract here, or to have resigned instrument of transfer resigned. So B has the B is entitled to resign the instrument. And the last, where a decree for specific performance of contract of sale or of contract to take lease has been made, and the purchaser or lessee makes default in payment of purchase money or other sums, who is the court has ordered him to pay. Firstly, if a court has given a decree for specific performance of contract of sale, if parties contract to take lease, but where after the decree of specific performance, if the purchaser is unable to pay the money, then or other sum which the court has ordered, then for this reason of default in payment of purchase money, the other party can ask for rescission of contract, and here court may adjust to rescind the contract. Now we will see section 36. Here it is talking about rescission for mistake. Rescission of contract in writing cannot be adjusted for mere mistake unless the party against whom it is adjudged can be restored to substantially the same position as if the contract had not been made. So under section 36, if a contract is not made or has not been made, so here if for the mere mistake, a party asks for rescission, and for that rescission the other party needs to be restored to the substantially the same position as if the contract had not been made. We have already discussed that what is means by rescission of contract, or what is the purpose of rescission of contract, that the parties will be in the same position if the contract has not been made. Here if rescission is for the mistake, and the other party who does not seek for the rescission cannot be restored to substantially the same position as if the contract had not been made, then court will not grant the order for rescission of the contract. So when the rescission is asked for mere mistake, then court will see that both the parties will be in the situation as if the contract has not been made. If the other party who didn't ask for rescission cannot be put into the situation where it was before, if the contract wasn't made, then court will not give the order for rescission of contract. This is written in section 36. Then section 37 is talking about alternative prayer for rescission in suit for specific performance. Here it is written that a plaintiff instituting a suit for specific performance of contract in writing may play in alternative that if contract cannot be specifically enforced, it may be rescinded and delivered up to be cancelled, and the court, if it refused to enforce contract specifically, may it direct to be rescinded. So there may be lots of situation under which first specific performance of contract is asked from the court. That situation is a situation under which court is not able or cannot give specific performance of contract or cannot give the order for the specific performance of contract. Then obviously court needs to give some relief. If in that situation, if the plaintiff who institute the suit asks from the court as alternative to rescind or delivered up to be cancelled, then court, if does not give specific performance of contract or does not give the order of specific performance of contract, then court will give or court will grant the relief of rescission of contract, or it will delivered up to be cancelled. So in short, section 37, where the court cannot order for a specific performance of contract, and there if the party or if the plaintiff asks also for rescission of contract in alternative, then if court cannot give that specific performance of contract, then court may give rescission of contract. Here court has the discretionary power. And last, section 38, here it is written that court may require party rescinding to due equity. On adjudging the rescission of contract, the court may require the party to whom such relief is granted to make any compensation to other party which justice may require. Basically it is said that the party who asks for rescission, okay, and a rescission of contract is given to him, and for that giving or as a result of rescission of contract, the other party against whom the rescission of contract is made suffered some kinds of injury for such rescission of contract, then the court will order the party to whom rescission has been given to do justice to the party against whom rescission has been given. Here court may order to give compensation to other party, like that, where justice may require. So in order to do justice the other party, this is an kinds of incorporation of equitable relief. Then what is the limitation period of filing a suit for rescission of contract? Here article 144 of the Limitation Act, here it is written that there will be 1 year for filing a suit for rescission of contract. So this is all about rescission of contract under specific relief act as a relief. And we also discussed about what is rescission of contract and when a contract will be voidable, and under that voidable contract a party may ask for rescission of contract. It is also discussed by us. Thanks for watching this video.